Thank you very much. I am Talivita Moses, and I am pleased that I am drawing your attention to a few aspects that I have already discussed, and I think this opportunity gives me legroom to expound on them so that you can have a point of reference, and maybe this can also be an opportunity to try to bring up to speed those that have not been attending class or those that in one way or the other did not take sufficient notes. Now, I am happy that in this semester I am facilitating training or building your capacity or knowledge on tourism business law, or even for those of agribusiness that are pursuing their studies specifically in relation to business law. So I am a lawyer by profession, and I have lectured in the School of Sciences since 2011. I am fortunate that I teach master's students. I teach them natural resources laws, either at national level, regional level, or international. I also have taught business, agribusiness rather, students. I have taught them land law, policy. I have also taught fisheries students, fisheries policies, laws, and institutions. I have also been fortunate that I have taught also petroleum students oil exploration, production, and development law. And I have also taught them oil revenues and taxation. And in fact, when I practice every other time the government budget cycle starts, and which moves in tandem with the tax cycle, I am privileged to be consulted to present alternative views, especially in the area of sin taxes or excisable commodities. So I am also a research fellow, a legal research fellow for the International Legal Consortium of the Campaign for Tobacco-Free Kids. And that gives me good grounding in speaking about business law, whether it is for tourism students or agribusiness students, because the foundations of these laws are the same. Now, allow me delve into the introduction of law, and that, of course, starts with introduction of the law, which is we can pick definitions from the Black's Law Dictionary or the Concise Law Dictionary to get good definitions of what amounts to law. Law, I mean the one we spell with L-A-W. Laws are rules and regulations that are made by a higher authority, and in the Ugandan case, because we're a democratic state, laws are made by parliament. So, in other words, it is the higher authority, which is the legislative arm of our government, and it makes these laws to regulate behavior, but specifically, as Article 79 says, that the function of members of parliament is to make law for the development, peace, and order of Ugandans. And business interactions, of course, would amount to what brings order, what brings peace, and what brings development. So, rules and regulations that are made by parliament to regulate citizens, members of a given society, or members of a given community, with sanctions for non-compliance, but rewards for those that comply, and they are enforced among citizens or members of a community. So when I say members of a community, I could mean professionals, and either those in the agricultural or in the tourism sector. I enjoin you to look for the actual phraseology or the actual sentencing or sentence construction for the definitions of what amounts to law. Law is also defined by others to mean the Constitution. And in our case, the Constitution is the supreme law of Uganda, and any other law that conflicts with the Constitution, it is the Constitution that prevails because it is supreme. This Constitution allows ministries, departments, and agencies of government to conform to what the Constitution provides in the event they are coming up with directives. You could call them ministerial directives or standards, and these all are intended to regulate good practice either in the tourism sector or in the agricultural sector, but basically in the business sector. So the Constitution authorizes members of parliament to make law through Article 79. And members of parliament can make laws, for instance, to make functional, like Article 39, which says Ugandans have a right to a clean and healthy environment. So members of parliament can make a law to functionalize Article 39. Members of parliament can also make laws to make functional Article 40, which talks about economic rights. And economic rights could also mean employment rights, rights to start up with rights, for instance, to establish a business of your choice, rights to be employed, rights to work within authorized time, and rights to even join a workers' or trade union of your choice. That is at place of work. So the Constitution then becomes defined as a law. But in this case, it is a source of law because it gives impetus, or it gives a yardstick or a measure on which other laws can be developed. And if any other law which is developed or practice does not comply or is not aligned or is not in tandem with what the Constitution provides, it will be declared unconstitutional, and for that matter will be unenforceable in Uganda. So I also said that laws must be enforced among citizens or among professions or among people who agree to certain things. Laws can either be public, can affect interactions or transactions that are relating to the public, or they can also interact in private affairs. Now, that's why we have public law and private law. We have international law and private law, and all those can either be private or public. Now, the examples I can give for public law, we have the Public Health Act, which regulates how we interact in public, and which regulates disease and transmission, which also regulates sanitation, proper disposal. It also regulates food consumption. It also regulates products that are developed to be consumed by members of the public. We also have laws that are interested in the public good or public order. For instance, the Penal Code, which is criminal law. And the reason why it is public, it's because anybody who commits a crime commits it against the public or commits it against government. And that's why it is public law. On the other side is the private law. Private law manifests itself in the law of contract, the law of intellectual property rights, the law of owning property. And all these are enumerated as we shall read in our subsequent classes, but also in the notes that I will provide. So the law has different categories, or as it seeks to regulate different interests. It either regulates public interests or private interests. For instance, in the era of COVID, every one of us realized that there were quarantines where people were not allowed to move from one district to another. There were public regulations, and this, of course, also is provided for in the Constitution. And the Constitution allows government to regulate or even limit freedoms, public freedoms, or citizen freedoms, or individual freedoms, especially if it is intended to prevent the spread of infectious or contagious diseases. Of course, most of the experiences until when COVID or Ebola or Marburg came, we were aware of quarantining of or limiting movement of animals in the case of whether there was a swine flu outbreak or the foot and mouth outbreak. But also at some point globally there were what were called bird flu or avian flu. So the public can be seen to regulate interactions, and that will be public order for public order. And in criminal matters, the public, or rather there are laws that regulate the same. Now, private, most of the business laws we are going to study about are private, or they interact, or rather deal with practice or interests that are private. Now, it is important for us to also appreciate that there are different arms of government, and different arms of government also find themselves involved in the lawmaking processes. Now, Parliament, which is the arm of government with legislative powers, when it legislates, it at times delegates power to the executive arm or ministries, departments, and agencies of government. And when it so does, that is what is called delegated legislation. A case in point is Parliament will make a parent act such as the Local Government Act, and this Local Government Act will authorize a municipality, a city, or a local government to come up with laws such as street parking, and street parking or garbage collection or tax levies or ground rent. Those then will be made by a local government council, but that can only be done when Parliament has authorized them to do that. Parliament also has reservations on making laws to regulate tax. That is the core mandate of Parliament. Parliament makes laws that levies taxes like the income tax, value-added tax, excise duty, and name them. And it could also allow local governments to come up with either market dues or garbage collection or for security or for utilities, among others. So Parliament will hand over enforcement of those laws to the executive. And the executive, once it has arrested or started enforcement, then it will hand over suspects to the judiciary. And the judiciary, in the decisions they make, those decisions become binding. And if anybody does what the judiciary has already done and pronounced itself in a judgment, then in that judgment would be binding on subsequent interactions or events or behavior that will ever happen that are related to what has already been adjudicated or pronounced or judged about. And that is called judge-made law. So the Constitution is law, which allows Parliament through Article 79 to make law. And when Parliament makes such laws, those laws are called acts of Parliament or legislations. They too are sources of law, and they are largely what we see or we have to enforce. A case in point is the Tourism Act, the Uganda Tourism Act, which regulates tourism behavior, tourism practice, and the industry and business and those that practice it. The Employment Act, the, the Trademark Act, name them. Those are made by Parliament and handed over to the executive for enforcement, and the executive does enforce through what are called ministries, departments, and agencies of government. So the second source of law, rather the third source of law, is what I said, that whenever the judiciary pronounces itself on a certain issue in public, then it has made what is called judge-made law. And judge-made law, through the precedents or past events adjudicated about or decided about, are subsequently impacting on acts, behavior, or decisions or interactions. Those are called precedents. Now, they are precedents. Precedents are also in different categories. One of them, they are what we call persuasive precedents, which means these are decisions that are made either that are made in other countries that practice Commonwealth, that have an impact or relate with what Uganda is. So they are not authoritative, because the authoritative precedents are those decisions that courts of record, such as the High Court, the Constitutional Court or Court of Appeal, or the Supreme Court, has made decisions about, and other courts that have binding effect on Uganda's judicial practice. So we have, in the order of precedence, the hierarchy is that the most authoritative are those decisions that are made by the Supreme Court, and Supreme Court decisions bind all lower courts. Lower in the sense that the Court of Appeal is subordinate to decisions that are made by the Supreme Court. And the Supreme Court may not necessarily be bound by decisions made from the Court of Appeal, except those that are constitutional in nature. The decisions of the Court of Appeal or the Constitutional Court bind the decisions that are made by the High Court. And the decisions made by the High Court indeed affect or impact or bind or influence authoritatively decisions that are made by the Magistrates' Courts. And the Magistrates' Court decisions, of course, bind decisions that are made by the local council courts. So the other source of law, besides the Constitution, the acts of Parliament or legislations, or decisions that are made by court, are what is called common law and equity. Common law and equity, you are aware that Uganda is one of those countries that were formerly colonized by the British. So in legal practice, decisions, or rather the law of Uganda, is largely informed by Commonwealth practice. And during Commonwealth, there were certain decisions that the law did not provide for, but they, in a way, were infringing on certain rights. And that's why we talk about the law of equity. And in class, I will expound more on maxims or principles of equity. A case in point is the first in time is the first in right. The other one is a monkey cannot decide a case against the forest, which means literally that if a decision is going to be heard, this must be heard by a person who is neutral. And that is why the judiciary is not Parliament and it is not the executive. So it is one of those arms of government that does or plays the referee or the arbitral role, or of listening and then making decisions, because it is independent. It is not having politicians. And that is why they say as sober as a judge. So principles of natural justice, that one should not be a judge in their own case. One should not be a judge, is literally translated in our traditional ways that you cannot drum and dance at the same time. So I will expand further in the event these draw questions I will definitely explain and give you a host of equitable principles or maxims of equity, which we shall talk about in greater detail. Now, after common law and equity, we have what we call customs, traditions, and practices. And I hope you are aware, we have many laws. For instance, the law which bans certain practices such as female genital mutilation, which previously used to be a traditional practice, and the law condemned it and called it illegal and criminalized it. So, and the law has also recognized certain traditions and has upheld them and has guarded them. For instance, the law that protects our marriages as institutions where families are based. And that, of course, we have the Marriage Act, and this also extends to traditional marriages, African marriages, and which are traditional institutions. And also the other is we have a law that governs cultural institutions, traditional and cultural institutions. We have a law that guards them, that recognizes them, because this is our heritage. So there are certain practices. Of course, also there are how we customarily own land, and that also is a good practice, which is protected by the law. Bad practices are also criminalized by the law. Traditional bad practices are criminalized by the law. Like I told you, the Female Genital Mutilation Act, things like witchcraft, those are bad practices, and the law indeed recognizes and condemns them. The other source of law for which I want to end is publications by legal scholars. And this, of course, if you want to know the various sources of law, it is important for you to read the treaty which establishes the International Court of Justice. It also lists some of what are sources of law, and these sources are different at international level and at the national level. It is also important for you to appreciate that we have laws that affect us regionally and impact on the economics. For instance, we have a treaty or a treaty which establishes the East African Community. And I hope you are aware that at the East African Community level, there are tourism practices that are interstate, meaning interpartner states, but also there are also agricultural transactions, business for that matter, that involve movement of goods and services. So we have a protocol which talks about free movement of goods and services, and I think you have at some point heard of what we call tariff barriers. But these international laws are encouraging the free movement of goods and services, because we also need to expand markets. And that is, of course, also why there's the African free trade, the African free continental free trade area. We have things like COMESA, we have economic blocs like SADC, and all these are intended to enable the movement of goods or transactions or services. And we also have the Common Markets Protocol. I did say about it, Common Markets Protocol. We have the Common Customs Union, which talks about taxes that are paid through East African transactions or purchase of goods and movement of goods. And it is in our best interest as students of tourism business or agribusiness to understand these different laws, because ultimately we are going to find ourselves engaged either as business persons in tourism or as consultants advising potential investors in this country or in the East African Economic Bloc. And these could be hoteliers, they could be tour agents, they could be agro-processors, they could be farmers. I say all this for God and my country. Catch you again in the next segment of tourism business law and agro-business. Thank you. Over.